morning. This time I'll call to order the November 7th, 2025 Subdivision and Development Appeal Board hearing to hear an appeal by the appellant of a decision of the Development Authority to refuse development permit application PL 202-40334 for visitor accommodation 27 units and employee housing 1 unit at 99 Three Sisters Drive. My name is Andre Gianandrea. I'll be the chair for the hearing. All questions and comments should be directed through the chair. I'm also joined by my fellow board members. At this time, I'll ask them to introduce themselves. To my right.
Bone, public member.
Deputy Mayor Tanya Faubert.
John LaFleur, public member.
Michelle Coos, public member.
Are there any preliminary matters that we need to discuss prior to proceeding? Oh, sorry. Go ahead.
Good morning, my name is Bonnie Anderson. Appellant World Mark. I did have some discussion with the applicant and their agent, Mr. Rick Grohl, and I will be giving you a package of materials that are already within the materials distributed. It's just to highlight some maps that are easily put in a package, but it's already part of the package. I believe Mr. Grohl, on behalf of the applicant, they have a whole PowerPoint presentation and they can't confirm that that's part of the package already. Plus they have additional plans. And so I think we need to discuss whether materials like that should be entered or not, because this hearing was peremptory and we haven't seen some of the materials until this first thing this morning. And so I think there needs to be a discussion about what exactly new they are planning on providing since the written submission deadline of Tuesday. Thank you.
Thank you. If I could just pause for a second. We didn't introduce our admin staff here. If we could start with
Ben Stiver, SDAB clerk.
We're sharing. Harry Schneider, manager, planning and development.
Gianna Bradshaw, development planner.
Mike Stasiak, community development engineer.
Okay, thank you. If the applicant would like to speak to the preliminary matter, please.
Good morning, Mr. Chair, board members. Rick Grohl, I'm the agent for the applicant as well as for the property owner. Yes, we have a preliminary issue about the submission of materials for this hearing. We have a PowerPoint presentation. My understanding from the procedures of your board is that we would, despite the submission deadline, we could still bring our PowerPoint presentation for today and could share that with you. I brought it to the attention of Ms. Anderson. She objects, and you heard her objection. In my view, that has nothing to do with whether or not the hearing was preemptory or not. My understanding from my conversations that I had with your municipal clerk, Mr. Stiver, that it would be still allowed to bring additional materials to the hearing, and it would be up to the board to accept it. What we have is a 31-page PowerPoint presentation from the applicant's architect, what guides you to through the materials that are relevant. Probably half of the materials in the PowerPoint presentation are excerpts from the plans and some diagrams where he explains his presentation, responding to the issues at hand pertaining to this appeal. What I like to request the board is Ms. Anderson made it clear to me that she could not accept the PowerPoint presentation digitally. If you would allow us to make a recess, we could have copies made at our cost here and then distributed it to the board. Or with your indulgence, we could provide you with the electronic copy of the PowerPoint presentation. It's 3 pages. We believe it's much more efficient for the hearing if you have the visuals in front of you. while Mr. Sparrow makes his presentation. And that's all I have to say. If you like me, Mr. Chair, to address the issue of the revised plans, we have submitted revised plans. They're in the package. There was one additional, I believe, 6 or 7 page document that I distributed to the clerk yesterday because we could not, our architect team could not update several pages that accordingly, as a result of the revisions, needed to be updated. And I've submitted that to the clerk. That's up to the board to decide whether you want to accept that as part of the evidence, but it's part of the set of revised plans, what pertains to 6 pages of the landscaping plan, what also needed to be updated accordingly because my client made some revisions to the approved plans. And because we submitted them on time, I believe they're in evidence before you. I see no prejudice to the applicant, to the appellant. I distributed it last night to Ms. Anderson. Our package got finished yesterday in the afternoon, and that was the reason for our late submission. Thank you.
Thank you. Any questions from board members on additional materials at this time?
Thank you, Mr. Chairman. It's Bonnie Anderson for the record. I haven't seen the PowerPoint, but obviously half of it's possibly new. I also haven't seen the plans because they were probably sent at 10 p.m. last night. So I don't know what I'm looking at. So right now, I don't think it's fair and reasonable to be accepting new materials, particularly when the items likely addressed are well known by the applicant for months. And it is a continuous, don't give me information, don't give me information, don't give us information, and then all of a sudden throw it at us at the last minute. This is all available in advance, and it is completely unfair to walk in here and suggest that a PowerPoint presentation to guide the board with new materials is appropriate without giving us any opportunity to review. And the fact that they're provided at 10 p.m. means they get to us before my drive potentially this morning, but I didn't see them, and I don't have them printed. So it is our submission that it's inappropriate to be adding materials at the last minute, particularly when all of this would have been available in advance. It is not a last minute issue to give plans and new materials at the last minute. Thank you.
I'm going to suggest we recess to discuss whether we accept this material or not and vote in buckets.
Mr. Chairman,
Oh.
before we recess. Thank you. I have one question. Mr. Grohl, how many pages is the new material?
The PowerPoint presentation is 31 pages, and the revised updated landscaping plan is 4.
Have that information? Do we have?
That wasn't, no, you don't have, but I've distributed it to Ben. Okay, thank you.
Motion to recess? Favor? The DAB will stand in recess for a period of time. Call the hearing back to order. The SDAB has decided to allow the PowerPoint presentation to take place today, as well as the additional 4 pages. We request that all parties receive a printed copy of that, admin, the board, and the appellant. We'll allow the appellant additional time to recess and review that, to adjust the response if necessary, and we will determine how much weight to put into that at time of deliberations as far as evidence. So with that, we'll proceed with the hearing. If it's possible to have someone furnish those copies while we proceed, that would probably be the most efficient way.
If you need facilitation of that process, you can email that to me, and then I can have the deputy clerk print that off. Yeah. Okay. Pardon me? Yes. Yeah. Correct. Yeah. Oh, okay. Yeah, we can do that. Yeah.
Thank you. Now that Now that the preliminary matter's been addressed, I'd like to approve the agenda. To board and administration, are there any additions, deletions, or changes to the agenda? I move that the board approve the agenda as presented. All those in favor? Opposed? To the appellant, do you have any objection to any of the board members present hearing this appeal? No. To the applicant, do you have any objection to any of the board members present here? Okay. Does anyone in the audience affected by this appeal object to any present board members hearing this appeal? I'll outline the hearing process and then we'll get started. The hearing process is as follows. First, the development officer will make their presentation, followed by an opportunity for the board to ask questions for clarification. At that time, the appellant will speak to the appeal, followed by an opportunity for the board to ask questions of clarification. I will then invite those in the audience speaking in favor of the appeal to approach the podium, followed by those speaking in opposition, and finally those speaking neither in favor nor in opposition. After all verbal submissions have been received, I will ask the clerk to read the names of those who have provided written submissions, identifying those in favor, those opposed, and neither those in favor nor in opposition. After all presentations have been heard, we may call a quick recess. After reconvening, there will be an opportunity for board members to ask questions for clarification. Any person who has presented will then be given an opportunity to ask questions for clarification through the chair or other persons who have presented. An opportunity for closing comments will follow, first from administration, then from any other party who has presented, and finally from the appellant. I will then ask those who have presented if they had a fair hearing. Lastly, I will conclude the hearing. The board will meet in closed session to review the evidence and provide a written decision within 15 days of this hearing. Does the appellant have any concerns with the process as outlined? No. Does anyone in the audience have any concerns with the process as outlined? And does the applicant have any concerns? Does anyone need me to go through that again? No? Okay. Presentations. We may call, in anticipation of a lengthy hearing, we may call breaks, recesses now and again, just to get everyone, let them catch their breath, and body breaks as we call them. Presentations for the development officer. Please proceed with your presentation.
The PowerPoint is based off the staff report. All right. Good morning, Chair and members of the board. My name is Jana Bradshaw. I'm a development planner with the town. I will be speaking to PL 2024-0334 at 99 Three Sisters Drive. I will also note that in this presentation, I am speaking to what was submitted in the staff report for that initial submission. I understand that there's new material and new grounds of appeal, and should the board have any questions, I am prepared to speak on those matters. Quick background here. The development permit was approved by the development officer on September 2nd, 2025 for 27 visitor accommodation units and 1 employee housing unit within 3 townhouse-style buildings. The uses approved are permitted uses within the CRD Commercial Resort District, and the application included 1 variance to section 4.11.3.5A to allow for a 10% variance in maximum building height from 12 to 13.2 meters. The application was approved with a condition that the development will build a minimum of 10% better than the NECB, or National Energy Code for buildings, which provides a community benefit through that enhanced green building. The map on the screen here shows the existing site. Pointed out is 99 Three Sisters Drive. The subject property is currently vacant and undeveloped, and it's located off Three Sisters Drive and adjacent to the Three Sisters Parkway. There is a wildlife corridor directly to the east of the subject site and the adjacent Worldmark Hotel to the southwest. The site is within the CRD Commercial Resort District, and the subject property has recently been consolidated with 95 Three Sisters Drive, which currently has applications with the town of Canmore as well for that balance of the land. I will make a note that this is a very complex site, as you can see, with multiple districts and that recent consolidation as well. The municipal development plan outlines what's to be expected in this area, on this property. This land falls within Section 10, the commercial and mixed use area, in which a visitor accommodation use is appropriate. The municipal development plan further identifies this area as tourist service commercial, which is intended to function primarily as tourism, service-oriented areas, providing hotel developments and a variety of retail and service uses. So the proposed visitor accommodation use is appropriate based on the intent of the tourist service commercial area as outlined in the municipal development plan. There are numerous sections in the land use bylaw that were applicable to this development and were reviewed throughout the process as well. Those are listed up on the screen here, as well as in the staff report. In terms of the height variance that was granted, this was reviewed in coordination with the land use bylaw provisions. And this is what sparked the appeal period for this file here. So the maximum permitted height is 12 meters for visitor accommodation, and a 10% variance was requested to that to increase the height to 13.2 at the highest points. It was indicated that this would help to accommodate the minimum floor-to-floor heights and roof pitch as per the architectural guidelines. And the proposed development was determined to comply with all other land use bylaw requirements. Section 1.14 outlines the variance authority and determines that the development authority may grant variances to the standards and regulations of the bylaw as part of the development permit approval process. And then another portion of that speaks to that if there is a community or neighborhood benefit and the proposed development would not unduly interfere with the amenities of the area or affect the use, enjoyment, safety, aesthetics, or value of neighboring properties. Based on the submitted rationale and impact assessment, it is the opinion of the development officer that the proposed height variance does not adversely impact access to light, access to views, or privacy of neighboring properties, This is also offset by the enhanced green building standards. There are slides here that respond to the notice of appeal that was initially submitted. These are detailed in the staff report as well, so I won't go through them in detail, but there's response to the points that were outlined in the notice of appeal here. So it speaks to the shared access and parking, as well as the height relaxation, which I detailed earlier in this presentation. And as per the MGA, section 687.3C and D outline the options for the Subdivision and Development Appeal Board when making a decision on a development appeal. And there are 4 options for consideration here. Approving the application subject to the conditions in Schedule A, approving the application subject to any revised conditions in Schedule A which the SDAB deems necessary, refusing the application specifying reasons, and postponing the application pending submission of additional details. Administration recommends that the Subdivision and Development Appeal Board approve PL 2024-0334. The recommended conditions are included in the staff report. Thank you.
Okay, thank you, Ms. Pratt. Any questions from the board? Thank you. The appellant may now make their presentation, please.
Not a tech person. Good morning. As previous, thank you for this time this morning already spent on the preliminary matter, and we will proceed now to our appeal. My name is Bonnie Anderson, and I do have with me General Manager of the client, which is Worldmark, the Club, Inc., which I will refer to as Worldmark. We do not act for Grand Canadian, however, they have supported some of our materials along the way. Because this is the merit hearing starting from scratch and other preliminary matters might not have been, might be a little bit of repeat of the intro stuff, but I'll try to skip through it fairly quickly. Again, our submission is filed on behalf of Worldmark. Worldmark owns and operates a visitor accommodation with 119 units, which is immediately adjacent to the proposed development. In fact, the lands owned by the applicant and the lands owned by Worldmark share a joint property line almost 200 meters long, so it's quite right up against each other relationship. No intervening road in those 200 meters of joint property line. Again, we don't represent Grand Canadian, but Grand Canadian is attached to our building. So we have one long building, and part of it is Worldmark, and part of it is condominiumized and run as Grand Canadian Resorts. It's actually a condominium, of course, that owns the lands. In 1997, one large visitor accommodation building, and I won't take you to that right now. Oh, we'll come to it. But one large building was approved by the Canmore Planning Commission, and it is across what becomes lots 2 to 5. And that large development was on one large parcel at one time, and that large parcel becomes lots 2 to 5, which I'll explain, and why I've given you copies of map and, oh, do you want to put them up on the, sorry. And we'll get to that in a moment. Worldmark and Grand Canadian have provided copies of letters from those organizations as tab A and B to our submissions, and they have outlined the historical usage of the 187 parking stalls that were allocated to the development. So those are again at tabs A and B, and they have indicated their peak times and seasonal peak times within those letters are going to be exactly the same as the peak times of usage of the parking area, et cetera, as the proposed development. The reason why we're getting into some of this, and in particular the parking, is because we suggest the land use bylaw was misinterpreted and or there's an additional variance required for parking. So normally with permitted uses, you can't get into a whole lot of detail about particular items, so we've focused on a few that are allowed to be discussed when it is a permitted use appeal. The original development permit, which is development permit number 97-363, I'll refer to it as DP 97363, or perhaps the 1997 development permit. And as noted in our original submission, our grounds of appeal are related to visitor accommodation not being a listed use given the zoning issue. And ground number 2 is a parking variance. Ground number 3 is related to the comprehensive plan and the shortcomings on that and the misinterpretation of the land use bylaw with respect to that. So they still sort of stay within the same pockets. Additionally today, because we received a number of materials on Tuesday from the applicant, we will have some additional verbal submissions relating to some of the items noted in that submission. So by way of preliminary matters, just to get ourselves oriented as to where everything is on the land, we have up on the screen and before you, this is part of the package, it is Plan 981-3497. So this is important for purposes of understanding the scope of the development that was originally built, and that it was built across a large lot, and which has since been subdivided. So this is the lot that was subdivided out in 1998. This is what I refer to as original Lot 1 or Lot 1. It is the original parent parcel for the development prior to subdividing lots 2, 3, 4, and 5 out of this. So it's important to note that that was the entire site. And so when we get into parking for the development and parking across the site, this is where we start. Next page. So by 2001, so that's after the development is approved in 1997, 98, in 2001, the site is sliced up. However, the building itself is largely in 2 and 5 but does straddle over into 4. The parking is the most important item on this, and there will be a visual coming up soon where you can actually see the building superimposed on the on where the property lines are. But it's important to note that the parking that was allocated to the development, which is Worldmark Grand Canadian, the one long building, was actually throughout the site. So 187 stalls for that use were across the whole site. And then the site got divided up. So when the Development Authority had mentioned that it's a complicated background, this is some of the complication. It starts out as one site and gets divided. The building itself actually gets divided in the sense that Worldmark owns their part, and the lower part, though, is Grand Canadian. In the visual, the lower part is Grand Canadian. Lot 5 has since been condominiumized, but I still refer to it as Lot 5 because the condo corp number really doesn't make much difference. And so we will proceed along with the visuals, and then you'll be able to see where I'm getting to. The next visual, please. So this is the zoning map. You can still see the same lots. There's 2 is noted in 2 places. That's because part 1 of 2 is in the middle, and then part 2 of 2. It's just because there's an intervening road, but that doesn't impact the assessment. But if you're wondering why there's 2 2s. So when I refer to, in the presentation, reference to Lot 2, that's Worldmark owns that. When I reference Lot 5, you can see the building on here. Sorry, I should emphasize that. Lot 5 is a condominium, but I will refer to it as Lot 5. And lots 3 and 4. Lots 3 and 4 have since been consolidated, but for purposes of zoning and for purposes of the application, the division line between 3 and 4 is still critically important because the zoning still follows that line. So lots 3 and 4 have since been consolidated into Lot 6, but again, I'll refer to them as 3 and 4. So that lays the groundwork for where the building is in relation to the lots. Our appeal issue number 1 is related to zoning. And the town's land use bylaw provides as follows. At 1.10.0.4, it says the development authority shall not approve a development permit for a use that is not listed as a permitted or discretionary use in the relevant district. When we had a look at the plans, and the plans have been around for probably a year in some form, we noted that the yellow area, which is part of the development permit area, is actually zoned CC, which is local commercial district. And the rest of the site to the right is zoned CRD. So the dividing line, the property line between CC and CRD, as you can kind of see it mimicked in the excerpt from the development permit, the dividing line, CRD is on the right, CC is on the left. CRD lists visitor accommodation as a use. Unfortunately, the area in yellow, visitor accommodation is not listed as a use at all for the district. So the original plans and the plans that were submitted with this application have the yellow area, which does not have a use, the use that they've applied for. So again, they've created basically an end to the yellow area, and that does not have the use that they've applied for as a listed use in the district. And one of the primary principles of municipal law is you can't approve a use for land where the district doesn't list that use. So that's the yellow area. So that's a background to kind of the primary issue that we first looked at and that made quite a large portion of our initial submission. The reason why the plans are so important at this point in time is the applicant has made revision to the plans now. So they've taken the yellow area out. However, they've taken the yellow area out at a last minute point in time, so we haven't had time to assess what's left of that and whether it complies with the land use bylaw in terms of setbacks, et cetera, which is why I was emphasizing why things are coming to us so late. And so in theory, they have quote unquote corrected this issue potentially, but we still have some further comments on that. And that correction just came to us on Tuesday with some further plans this morning. So this first ground of appeal, we say, is depositive, meaning that if they can't overcome this first ground of appeal, you can't actually go further because you are not fundamentally allowed to have a use that's not listed in the district. So long as that yellow area exists, it's a problem. And it appears that the applicant knew of this problem for quite some time because they have tried to make a rezoning application. I don't know why it got stalled, but nonetheless, they made a rezoning application in February. So to me, this issue has been known to them for quite some time. And we have cited a few cases in our materials regarding the very strict rule that if you don't have a use and if they don't deal with that yellow area, you can't actually approve the development permit as applied for. Even if it is just a small portion of the land, so long as that small portion of the land doesn't have that use listed, you can't approve the development as a board, as a development authority, and you can't approve it as a board. So that's our first ground of appeal, and I will touch upon it a little bit with respect to comments on what they submitted on Tuesday, but for now I'll follow our initial submission as originally presented. I will turn to the next page, which is a copy of the plan, page number 6. Oh, page 5. Yeah, sorry. There we go. So this is, again, in the materials. Sorry, I don't know what tab it is. It's probably tab 15 or something like that in our materials. This is actually a copy of the original plan that was approved by the Canmore Planning Commission for the parking stalls. Again, the whole reason we're talking about this is because at the end of the day, we're suggesting there's a variance to parking stalls. Otherwise, we wouldn't be able to raise this issue. You can see how the development, largely kind of in an S shape, is similar to the visuals seen previously where it was faded in the background as to what is actually constructed. Although faint on this plan, you can see where the parking stalls are. Oh. Apparently a lake. But you can see where the parking stalls are, and the next visual will help with the parking numbers there. So this is from the original Canmore Planning Commission approved plans, and it does say that it requires 187 stalls. So the whole crux of our argument on this front is that this development permit was approved for the entirety of Lot 1. It gets chopped up later, but nonetheless, this parking requirement is required for the entire original parcel. That was what was approved by the Canmore Planning Commission. So 187 stalls are required for Worldmark Grand Canadian Building alone. It is uncontroverted that is and what was approved originally, and what actually exists on the site for the last 20 plus years. Next slide, please. And apologies, but this is the way this one came to me. It is, the building was amended just a little bit in 1999, just to move it a bit further west. This is north is up that way. But nonetheless, I think this is a clearer picture of where the parking stalls and the site, the original development permit approved site is. It's the larger site, 187 stalls were provided for this building that exists, where Worldmark and Grand Canadian are. Again, Grand Canadian's at the right side. You can almost see the line as to where the property line divides it. This is original Lot 1. This is what was approved in the original plans, slightly revised in 1998, as you see here. But you can see how the access, the road on the left side is Three Sisters Parkway. You can see there's an access off Three Sisters Parkway. You can see there's a curved internal access with a number of parking stalls on each side. And then the entrance to Worldmark is the first traffic loop, and then the access to Grand Canadian Resort is the second traffic loop. And again, parking is all along the access. Part of the parking, at least 50% I believe, has to be located underground. So under the Worldmark and Grand Canadian, we also have a bit of underground parking. So 187 stalls are not at grade, some are below grade. But nonetheless, this gives you a good picture of what the intention was with the original plans and what was originally approved with that development permit. That covers the entire site. You'll also notice at the end of the sort of dark blue area, there's a jut out of a square bit. That is an underground parking area that was, might be better visual, sorry, I'm just gonna. I'll describe it here, sorry. Yeah, can you go up? Perfect. The underground parking is just at the very end of the blue building. I wish I had that. Yeah, just that outline, yeah, that outline is actually the extension of the parkade, underground parkade. And just to the left of there is the ramp going down to that parkade, just, yeah, right there. There's a mutual ramp. So when this site gets divided up, part of that underground parkade, you'll see just the outline. It's not in blue, but it's an extension of the building. That goes into the new Lot 4. And so when this site gets divided up, that's part of the building is into Lot 4. And just with respect to the next visual, or, yeah, so with respect to the development permit that was approved in 1997, we have an associated development agreement. And the development agreement articulates what the conditions of approval for the development are, and lays out security, levies, all those types of things that might be in a development agreement. Importantly, in the 1998 development agreement, the site is referenced with the original site that was owned by Three Sisters Resorts at some point in time, so it's a broader definition. But by the time you get to the 1999, the big lot that we saw in the visual before, that becomes the development site, which is important because what was approved at the end of the day relates to either the top definition or the bottom definition, but nonetheless, it's the large site. So the development permit covered the large site, one long building occupied now by Worldmark and Grand Canadian, with 187 stalls allocated to that use. Next slide, please. Or page, sorry. So these are excerpts from the development agreement. I don't expect you to read them. They're just reiterating the fact that on the top one comes from the 1998 development agreement, the middle one comes from the 1999 development agreement. Nonetheless, both say that 187 stalls are to be provided for the development, which is the building that you've seen before or seen on the other visuals, plus the site. The defined development site is the larger site. So the development was always intended to be across the whole site, and again, with the one long building with 2 parts to it. And the last item there, which is a number 5, that's an excerpt from the actual conditions of approval. So you've got the development permit plans that say 187 stalls. You have a condition of approval, which requires 187 stalls. And then you have the development agreements, 1998 and 1999, which require 187 stalls. Next slide, please. So, in going through the materials, we found this plan, which was super helpful, to describe what was intended for the parcel as future developments came on board. At least in 1999, when this plan was drawn, that is exactly the same as the 11 by 17 plan I gave you. The reason I gave you a different copy was because you can't really see the shaded areas in this one that was scanned, so I apologize, that's in your record perhaps. This 11 by 17 clearly shows in the background kind of the items we're hitting now, which is how is parking to be allocated. And while the future buildings marked in yellow on this plan were never set in stone, they do give you a very good idea that if you look across the site, the parking layout was intended to be in a particular way for the Worldmark Grand Canadian building and the 187 stalls. And then the yellow part with the proposed commercial building on the left in yellow, that's in lot 3 now, and the proposed timeshare building in yellow at the upper left part of the site, they would get additional stalls. The whole point of showing this is you've got some stalls in black. This is not perfect because the stalls just outside of Worldmark that are labeled in yellow actually got built with the original plan. But it does give you an idea as to the type of uses that we're looking at going in on the 2 sites that we're now dealing with, lots 3 and lots 4. Importantly, it says proposed parking stalls. So our point is that when this development permit was approved, 187 stalls were allocated and required by our development, and the 2 proposed developments possibly coming in have additional stalls. And so part of our argument is that we have a use that was guaranteed 187 stalls. We have a new use coming onto the property, and our argument is that, or a submission is that, that new use requires its own stalls. They can't take away from the 187 that's already allocated to Worldmark. They need their own stalls, and that doesn't occur. So we're having a shortfall. So essentially you'd have 187 stalls allocated to the original use, which is our clients and that of Grand Canadian, and then you need an additional 29 stalls for the new use coming on board on lot 4. That's actually not what's occurring. 20 stalls have been removed on lots 3 and lot 4. So we're running into a shortfall, and I'll get into that in a moment. But the point of showing this is it shows that it was intended that the original use gets its own 187 stalls, and new uses are having to get their own as well. Um, And we can go to from here if you don't mind, sorry. Oh, next one. Yeah. So this is a good visual. It's from 2007. I have added green, orange, and pink to it, so I apologize. The yellow was already there on the copy. But this is part of the 2007 easement, and it helps to show where the actual stalls were built. And what has occurred to date is the stalls in green, they are in lot 3 and are still open for our client to use, and they've always used them. They're part of the 187. But what I can tell you is that the part that's in orange or brown, those 20 stalls and that access have been completely closed off. So we no longer have access to 20 stalls. So when I was talking about the 187 original stalls, they've taken away 20 already, and we don't expect to get those back there. But their new development requires 29. So we've got a deficiency for our stall count, and then they've got 29 for themselves. So our position is that we were always approved for 187. The development permit covered across the site. If you want to put a new development in, that's fine, but you don't get to take away stalls that were provided to our development in 1997. Now, there have been a number of development permit applications, not that many, since 1997. There were a couple for signage and for a few minor amendments to employee housing. But those development permit applications, since 1997 to date, none of them have changed the parking allocation to our development. So at all times, even when employee units change slightly, there is no development permit that amends the 187 stalls allocated to Worldmark and Grand Canadian across the whole site for their use. To point out, because the building does extend into lot 4, I apologize, we can't really see it that well, but the lot 4, where they're proposing the new buildings, you can see that I've highlighted in red, that's the parkade that extends into lot 4. So we saw that before, it's a jut out. And so what was to occur was that the ramp would go down into the underground parkade in our client's lot and immediately veer off into lot 4. So there actually is an extension intended into lot 4 with the underground parking. And I'm going to assume there's probably a knockout wall in the underground parking, because when lot 4 was being developed, that would be naturally a spot to do the underground parking. As part of this proposed development, there's no underground parking. They have got just above grade parking, so the part of the parkade underneath just kind of sits as a building with into lot 4. And I should point out that in our materials, we have included a sign. There was some discussion about a sign being in a particular location, and we are opposed to it being moved. In the materials, we refer to the sign permit as 2004-500. It is, I believe, tab 21. I should correct the record. The sign permit for the signs is actually development permit 2007. 039. And so there's some question that the World Mark sign at the corner of the current access off Three Sisters Parkway should be moved. And our position is that it is an approved sign. It has a development permit, the development permit 2007-039, and it is in a location where the easement allows it to be. So it is our position that it cannot be moved to make way for the proposed development. And we can go to the next page. And I do want to show that there, this was part of the materials provided by the applicant, at least to us at one point in time. This is a layout of the building and site back in 1999. I believe it was done by Three Sisters Resorts. It largely follows where the buildings are. This particular schedule is to a mining setback. You'll see the cross-hatched area on the right. The whole point of showing this slide is you can see where, you know, taking visuals from the other ones we've provided, it's pretty consistent as to where parking was to be located. And you can see on Lot 3 and Lot 4, the extended buildings, kind of similar to the 11 by 17 plan that you have, just a sense as to where buildings would possibly go on Lots 3 and 4 at the end of the day. I should point out that it looks like there's additional parking off to the left. That is part 2 of Lot 2. That's that one segment of Lot 2 that's bisected by a public road. That parking was never approved there, so this is just sort of a sketch, primarily for the mining setback. But it does provide a consistent layout for the site in general with respect to parking, which is the point of why I've included it. We can go to the next page. This is a plan from 2009, again, largely showing where everything was to go. And this is where, in red, you can see where the parkade juts out into Lot 4. And by the time of this plan, which is 2009, Lot 4 is created, because Lot 4 was created in 2001. So it is a building that extends into Lot 4. And the next one. This is just a little bit closer view. There's 2 easements for built structures or patio. Again, the upper one is for the parkade that goes into Lot 4, and there's an additional easement for a patio that goes into Lot 4. We have no problem removing the portion of the patio past the yellow area, so I believe that's not a point of contention, but I'm just pointing out that there are structures and or improvements within Lot 4. And I think we just end with the last one, which is, again, just to highlight, you've got that one on 11 by 17 in front of you, so I don't want to belabor that one. But at the end of the day, what the picture we're trying to paint is that 187 stalls were allocated under the original development permit for our building that is constructed and been in operation for close to 25 years. And that future buildings and future developments, like are proposed today, were actually, even back then, envisioned to have their own parking in addition to the lots that we already have as part of our 187. And the reason why the 187, as I mentioned before, is so important is that our clients arrive at our resort and Grand Canadian Resort primarily by car, given its location. The site is actually quite sloped. I had not been out to the site. I keep looking at plans like this thinking it's rather flat. It's not actually, it's tiered. So the parking available is quite restricted. You can't just slip in it in any, blank area, because often the blank areas on these plans indicate either a sloped area or a landscaped area with trees. So, yeah, you know, if there is a possibility to create more lots on our property, we would be happy to do so. We just need to cooperate with the town to do that, but at the end of the day, we are allocated 187, and we are saying that the new development needs its own 29, which hasn't been provided, because they took away 20. They already closed off part of the lot, took away 20 from our 187. So, okay, so what I will discuss next is some items related to some of the submissions that came in with respect to Tuesday's materials, which I didn't have in advance, so we will give verbal submissions to some of those items. It is our submission that this board does not have jurisdiction to expand the size of the assessed area to twice of the application. And that result is because of the consolidation of lots 3 and 4. Midway through the application, we have a development that is proposed on lot 4. All of a sudden, we have now a development that's taking into account lot 4 and lot 3 because it's now consolidated. So our position is that this board does not have jurisdiction to double the size of the initial lot. And what it does is it just causes confusion as to what the proper setbacks are now. Because we had 2 lots to deal with. One was lot 4. We now have lot 4, lot 3, consolidated as lot 6. To tell you the truth, I've been doing this for a very long time. It's so difficult to tell what's the front yard, the side yard, the rear yard. Do you need a 9-meter setback, a 15-meter setback? Can you get a relaxation, or can you get setbacks down to 0? It is just a mess, to say it kindly. And again, I've been doing this for a long time. I can't even figure out some of the setbacks. But I would say that it's a very confusing application to have started with 1 lot and expanded with a comprehensive plan to 2 lots. And the parking doesn't, to me, make any sense. And so I'm a little bit lost as to how this board can accept the expansion of the assessment at this late period in time. Nonetheless, what we have to say about the submissions that came in on Tuesday, which are revised plans, and I haven't seen the revised plans from today. However, it is our position that this board does not have jurisdiction to approve plans that go into that yellow area in lot 3 that is currently zoned CC. So any plans that go into the yellow area do not have the proper use, and as a starting point, those cannot be within plans that this board approves. It has been suggested, I believe, in the materials that this board can condition a change to the plans so that the yellow area is removed as a condition, or a change to the plans that meet the requirements of the Development Authority, or to the satisfaction of the Development Authority. It is our position that you cannot condition that yellow area to be corrected at some later point in time. This board must have before it plans that either have the yellow area removed, have the yellow area removed. And the assessment has to be done on the basis of the yellow area removed, which we haven't seen yet. So again, this board cannot condition use and zoning. So you can't sit today to say that at some future point in time, you can remove this from the plans. if any plans are to be revised or amended, they must be amended as part of this board, because you do not have jurisdiction to approve a plan that includes the yellow area. And again, if it includes the yellow area, that's an area where that use can't go at present. Rezoning needs to occur before. So in the materials presented by the applicant on Tuesday, they have suggested that the yellow area is just merely landscaping. It's a landscaping element. With respect, landscaping is not a use. Landscaping is a use made of land, but it's not a listed use. The listed use for that yellow area in Lot 3 is visitor accommodation, but that's not a use in that C district. So that yellow triangle cannot be part of the analysis if you want to fall within your jurisdiction, because the use is not on there. The use for the entire application for what they've applied for in Lot 4 is visitor accommodation, and visitor accommodation is not listed for that yellow area. Again, that cannot be conditioned with revised plans to be provided at a later date, or revised plans to meet the satisfaction of the Development Authority. That actually has to occur here as part of this process, as part of this hearing process. It can't be a condition of approval in our submission. And landscape elements is not a use either. So you can't create a use just to deal with the sidewalk, et cetera, that's encroaching into the lot where you cannot have it. So that's with respect to the revised plans, at least that I've seen so far, and their proposal. The second item I've already mentioned is that because the consolidation occurred midway through this application, we've got some assessment of Lot 4 on its own, some assessment of Lot 3, some assessment of the lots together, because they've been consolidated and are now considered a comprehensive site. We still suggest that comprehensive site or sites alone, you don't meet the parking. And the use suggested for the comprehensive plan on Lot 3, which is the lot to the left, they have suggested that, I believe it's restaurant, but it might be changed to retail, and then now it appears to be potentially visitor accommodation. When we're looking at the parking and the original allocation of parking to Worldmark and Grand Canadian of 187, in order to build those developments, the development on Lot 4 that's proposed now, the conceptual development on Lot 3, you're going to be removing 37 stalls that are originally allocated to Worldmark. Because there's 37 stalls, there's 17 on Lot 3 and 20, well, there's not exactly 17, but I apologize, there's 2 sets. But essentially what they've done now is they've closed off 20 stalls already. So past the ramp into Lot 4, all of that area is closed off. So we already now are lost 20 stalls. So we've gone from 187 to 167 without notice. Well, we had a bit of notice, but without amending the development permit to do so. So we've lost 20. On that side of the property, the part that they're applying for right now, they're going to put 29 in replacement of. So that actually suggests a shortfall of 9 because we were already allocated 20. They took away 20, so they're actually only providing 9 stalls. And that's the variance that we're talking about, is 187 were allocated as part of the original development permit. You can certainly have another development permit that relates to those lands in Lot 4 now that it's subdivided and wants to get redeveloped, but you can't take away original parking allocation. So they require 29 stalls, and they've taken away 20 from our client's and Grand Canadian's allocation. So in our respectful submission, they're falling short. They're really only providing 9 stalls because they've taken away 20, they're providing 29, so they actually only are providing 9 stalls. So in our respectful submission, they're about a 58% relaxation in respect of the actual parking they're providing for their own use. You can't take away 20 and provide 29 and say you're providing 29. They actually took away 20 and providing 29, you're actually only providing 9. So there's about a 58-60% relaxation of parking stalls just for Lot 4 development. And in our respectful submission, when you have a variance that's over the allowed variance power of the Development Authority, which is 10%, this application in our submission should have always gone through Canmore Planning Commission. Any variance above 10% requires that the application had to go through Calgary Planning Commission. The reason why that's important is there's a case called Thomas, and we've put it in our submissions. The Thomas case indicates that if there is a mandatory land use bylaw requirement, like public consultation, in our case, large variances go to Calgary Planning Commission, it is our submission that you can't circumvent that. So, in other words, our submission is not only is the variance large and should have gone to the CPC, and by going through this process, we've skipped CPC. But also, the variance has a significantly negative impact on both of our clients, our client Worldmark and the adjacent Grand Canadian, as noted in the tab A and B letters. They are already short of 20 stalls. And when Lot 3 gets developed, there's 17 there, 37 total. When Lot 3 gets developed, they're going to be taking away those 17 stalls. So, in other words, we're kind of repeating what we're doing here is another very large variance, in our opinion, for Lot 3 development. I realize it's not under the current development permit, but it's certainly under the comprehensive plan that was submitted. So we're suggesting that the current development plus the future proposed development are going to woefully fall short of providing the appropriate amount of stalls with the 187 already allocated under the original development permit to our client and Grand Canadian. So with respect to another item raised by the applicant on Tuesday, is they suggest that there's no buildings with respect to the original development permit on Lot 4. And I think we've shown, and part of the reason why I highlighted, the actual parkade, underground parkade, is actually a building, and it actually does go into Lot 4. So the statement that there are no buildings on the statement that the Grand Canadian and Worldmark building is entirely on lots 2 and 5 is actually not factually correct. There is actually an underground parkade from Lot 2, our Worldmark building. There is actually an underground parkade that extends out into Lot 4 that's being developed right now. You may recall on some of the visuals I highlighted where there's that easement area, that parkade, underground parkade that was intended to be connected to Lot 4. And they've decided not to connect or build an underground parkade, which is fine. But part of our building does extend into Lot 4, and that was permitted under the original development permit. The only reason I raised that is because in the applicant submissions on Tuesday, they suggest that the development under that original 1997-98 permit only exists in lots 2 and 5. And that's actually not the case. Not only do we have a parkade extending out to lot 4, we also have 37 parking stalls that were allocated, 37 parking stalls that are within lots 3 and 4. That's in lot 3 and 4. We also have landscaping, lighting, and other infrastructure that are in lots 3 and 4 as the result of the 1997 development permit. We have a paved access out to Three Sisters Parkway. The reason I'm pointing this out is there's some suggestion that the development is entirely related to lots 2 and 5 under the original development permit, and that's not the case. The original development permit was all of lots 2 to 5, like 2, 3, 4, and 5. So that's why we have spread out parking, lighting. The parking is not temporary parking either. It's paved. It has electricity to the stalls. It has lighting. So we just wanted to make that correction on the record, is that the development approved in 1997 is not just located in lots 2 and lot 5. Another item that's raised in the applicant materials that I do wish to comment on, verbally at least, because we didn't think we could add submissions in today, so I was just going to do them verbally. We just received part of this on Tuesday, is that with respect to development permits, within the applicant submissions from Tuesday, they make some reference to development permits not being registered on title, and to lots 3 and or lot 4. They also make reference to development agreements not being referenced on title. And those are the excerpts that I threw up on the screen before with respect to the 187 stalls. I mean, the development agreements are large, but that's part of the condition. And that they appear to suggest that because the development permit is not registered on title, that it doesn't bind them, that it doesn't apply to lots 3 and 4. So essentially, from what I can garner from the argument, is that they are suggesting lots 3 and 4 are blank slate because there's nothing registered against title. Well, if you know anything about land titles, development agreements or development permits are never registered against title. If development permits were registered against title, I should have one for my home against my home title. I don't. Development permits are not registered against title. They are actually a regulatory municipal approval. Development agreements that require you to build something that are associated with a development permit, they are often registered against title. So the development agreement that I referenced earlier, there was one for 1998 and one came a replacement for 1999 that shows the parking stalls. Those development agreements are typically 20, 30, could be 60 pages long. Those are registered against a property. So the development permit isn't, that's a municipal permit. However, the development agreement relating to the work that needs to be done could be registered against a title. So you probably see that. And but the registration of a development agreement against title is also not mandatory. I've been doing this for close to 25 years and I see all sorts of things. You have some municipalities who register the development agreement against title in full. They put a caveat and then they attach the whole development agreement to the registration. I see some municipalities that have a caveat with just the description of the development agreement, so it just has a date, no attached development agreement. And then I see other municipalities who have development agreements that never register them against title. So the only reason I raise this is because they are suggesting that because the development permit is not registered against title, development agreement is no longer registered against title, that must mean that there's a clean slate, blank slate, for lot 3 and 4 to just eliminate our parking and to just do what they want on their parcels. That's the sense that I get from the materials. development agreements that are registered against title, the Municipal Government Act requires that those development agreements be discharged once the activities required in the development agreement are completed. So the development agreements for this particular development from 1997, 98, the development agreements were registered in 98, 99. Sorry. And, sorry. Oh, okay.
To wrapping up their presentation.
Do you need, do you require much more time at this point, or?
No, probably about 15 minutes or so just to wrap up.
I think we have a request for a break, if
Sure.
that's okay.
Thank you.
We'll stand in recess for 10 minutes. Thank you, everyone. Appreciate that. Ms. Anders, please proceed.
Thank you, Mr. Chairman, and members of the board. So I was talking about development permits and development agreements. So again, development permits never get registered against title. Nothing turns on that. And I was trying to think why that would even be raised. I think it's because when you do due diligence to purchase a property, you look at various things. If you're looking at a property, I do this because I was involved in a real estate department for a long time at Bennett Jones, Denton's. Depending on the complexity of the site, depending on what site you're looking at, redevelopment, taking down something, putting in something, you're always looking at what's there as a starting point. Are there any buildings? Are there any improvements? So the best I can tell from the suggestion, at least in the applicant's materials, is that they're suggesting because the development permit isn't registered, that it kind of doesn't exist for them. And I kind of tried to think of why, and then an analogy. I can tell you that in approvals and permits issued by Alberta Environment are not registered on title. It doesn't invalidate them. It just means that you have to look elsewhere for them. So when you're doing due diligence, either for a purchase or redevelopment of a property, you're doing your title searches, you're doing municipal searches, you're doing provincial entity searches. You get a full lay of what's gone on with the property. You'll do more searches, typically, when there's improvements on the property. So in this particular case, if you're purchasing Lot 4, you're gonna see that there's a parkade extending out into your Lot 4. You're gonna see that there's parking stalls there. You're gonna see there's light standards. You're gonna see there's a road. Lot 4 is not undeveloped. Lot 3 and 4 are not undeveloped. They're not a blank slate. They actually are and were an integral part of the original development permit that was issued for the whole property. So the sense I get from the applicant is, well, because it's not on title, all these things, that it doesn't matter and it doesn't apply. In our respectful submission, the original development permit still does apply. And the 180 stalls are still required. And so they don't just disappear because they're not registered. And the development agreement, which required those things to be built, the development agreement requires the stalls to be built. The development agreement requires the access to be built. The development agreement required the parkade to be built. Those development agreements are no longer on title because they're satisfied. The MGA, Municipal Government Act, requires they be discharged from title. So you shouldn't find them on title 20 years later. Presumably the development's built. And the development agreements get discharged from title. When you go for financing for a property, you see this old development agreement and go, why is it still there? It gets discharged if there's nothing left under that original development permit to do. It's completed. So it makes sense that there's no development permit registered against title. It makes perfect sense that there's no development agreements registered against title anymore. Again, development permits never were registered. Development agreement gets discharged and is required to be discharged once the development is built. So there's nothing on title. So in the materials, when you read the materials regarding what's on title and the fact we can't find any of this on title, doesn't mean the development permit doesn't exist. Doesn't mean the development permit obligations don't exist. Again, think of Alberta Environment. None of those approvals are registered. You can find them, but they're not registered on title. So the applicant to me is suggesting, because they can't find anything on title, that for some reason they're not bound by this development permit and the 187 stalls that are required by it. So our submission is that it never was registered against title, and it doesn't mean that it doesn't exist, and it doesn't mean that it doesn't apply. Another couple points is the shared parking strategy. And this is where we get into the variance on parking. And the land use bylaw at in section 2.7, when you have a variance on parking, you can possibly have a shared parking arrangement. And our submission with respect to the shared parking arrangement is the registration that's currently on title that the applicant suggests governs shared parking. We can't even agree as to what the interpretation of that agreement on title is and what it means. So it's our submission that we're not sure how this board or this development or the development authority think that it covers the current situation. That shared parking, it covers a lot of things. Sorry, there's a number of things shared within that 2007 easement. That shared parking agreement, if you will, was registered, drafted, executed in 2007. You may recall from my presentation that the building hasn't changed since really 2000 much. And certainly the development permit hasn't been amended by way of parking or anything. So in 2007, we have the same thing we had in 2000, the same building, same development. So in 2007, you don't, according to contract interpretation, take the context now to apply to a 2007 agreement. The 2007 agreement, according to contract law, is to be interpreted in the context at the time. In 2007, the context at the time was the development permit from 97. That was built, the 187 stalls that were built, the 150 visitor accommodation units that are built within the two buildings. That's all the same foundation in 2007. We don't get to import stuff that is now and conceived now and designed now to interpret a 2007 document. The 2007 document is interpreted as to what was in place at the time of the document. And we suggest what's in place at the time of the document: development permit 97-363. The 1997 development permit and the development that relates to that permit. Never changed in any substantial way over the last 25 years. Not changed. So again, that's in response to the applicant's submissions that for some reason we have this parking arrangement that we can share now based on this new development. If we have a parking arrangement that we can agree to at this point in time related to the proposal that's actually before us, that to me would be a parking arrangement that we should register on title related to the development permit being requested today. 2007 circumstance is not the same as today. Today we have a different development. It's 29 units on lot 4. We don't know exactly what's on lot 3. We have a ghosted plan for lot 3. Nonetheless, the point of it is the 2.7 parking requirements, in particular 2.7.2 shared strategies. It is our submission it can't be based on a 2007 agreement that didn't even contemplate the development we're now looking at. So if the development authority is going to accept a shared parking strategy to deal with the shortfall of parking, the reduction of our parking, and know the sharing mechanism in a 2007 agreement that we can't seem to agree on, even the parties involved in that agreement, as to what it means. We say that it's a variance, a significant variance in parking, and that it doesn't meet the requirements for a shared parking arrangement because we actually don't have a shared parking agreement on title as required by 2.7.22 that relates to the current development. That was never in sight in 2007. We didn't have those details then. So if there is to be a shared parking arrangement, a shared parking agreement that is satisfactory to meet conditions now, that's fine, but we don't have that. So we suggest that the variance and any shared parking arrangement does not meet the requirements of 2.7.2. The other item we raised previously is a shared parking arrangement under this 2.7.2 shared parking criteria, if you will, in the land use bylaw, requires shared parking to typically occur where peak times of the to and going of parking persons that are parking are different. So if you can imagine, you've got a parking lot for a residential use, which maybe isn't busy during the day, but it does get busy to and from the end of the workday, and certainly overnight. And then you can slap in parking for retail, because retail peak period might be during the day. The whole point of shared parking strategies is you've got two different peak points in time of peak usage. What's proposed is visitor accommodation. It's exactly the same as our visitor accommodation with the same peak times. We say that doesn't meet the criteria for shared parking as articulated in the land use bylaw. And we say it's an interpretation or misinterpretation that the shared parking requirements have been met, because they haven't. In order to have shared parking, and in order for it to work effectively, you've got to have offset peak times. Like I said, a residential building that uses parking from night till morning, overnight, is very easy to coordinate with a retail use, because the retail use will be peak during the day. So you've got to have different uses in order for shared parking to work. And so the requirements within 2.7.2, et cetera, regarding shared parking, we say are not met here. So we've got 20 stalls eliminated from the 187. We've got 29 proposed on 20 removed that are of the 187, 29 new proposed, layering on top of that. So you're really only providing 9 of the 29. A significant variance. And then we're suggesting that the shared parking criteria is not met, because we are going to have on a very, very tight site, which is sloped, we're going to have peak parking times at the same time as this new development. In other words, the variance will have a significant impact on the operations of Worldmark and Grand Canadian, and the shared parking arrangement is not going to work to alleviate that. It will only exacerbate that. The other item raised with respect to, on top of the items raised on Tuesday, is that municipalities have limitations on dealing with development permits on their own. So this is an initiative by the applicant and supported by the Development Authority to basically start with a clean slate on 3 and 4, ignore original development permit 1997, and shared is going to work in some fashion. And our submission is there's a huge variance, and that variance must meet the test of 687 3D which is, does it have a material impact or undue impact on neighboring parcels of land? That's the test before this board. And we say it will. It already has a significant impact with the reduction of 20 stalls and with the further reduction of stalls overall. The negative impacts of having sufficient parking for our clientele base is significant. And the beautiful thing about the parking assessment and what the needs are for the current uses is they've been operating for 25 years or close to. They have a pretty good idea as to what their clientele need, what they were allocated originally, and how that all works. And the peak times when our facilities are being used, you have 97 to 99% parking completely full. And that's in tabs A and B of our submission, the letter. Okay, and just a couple more items. Sorry, I'm just looking through my last notes with respect to the Tuesday submission. Okay. The one thing I did want to hand forward, and I apologize for not noting this before when we were talking about additional submissions, I do have the proper signage permit that should replace the one that's improperly in the record. Nothing turns on it really, other than you having the proper information. So I don't know, Mr. Grohl, I didn't give him a copy yet, but would this be satisfactory to provide to you? It's. Yes? Sorry, thank you. Sorry, I'll give them to Mr. Grohl. And that, by the way, relates to Lot 3 where they're developing, Lot 3, Lot 4. We have a sign there, and that sign is permitted and is allowed by the easement, and we're suggesting that it cannot be removed. So that's the other item raised in part of the materials. So I believe those are that's the end of my submissions at this point. We do have other comments possibly from the materials I've not seen yet. And then we have closing. So I think subject to questions, which may be now or later, those are our submissions.
Does the board have any questions or clarification?
Thank you, Mr. Chair. A couple of quick questions for you, Ms. Anderson. First of all, relating to 1.1411 of the Land Use Bylaw and 6873D of the Municipal Government Act. Two questions. First of all, if the applicant were to install or build an additional 3, 6, or more parking stalls, either at the surface or in the parkade stub, would that benefit your client? Would there be benefit to your client if additional stalls were built?
Yes, if the stalls that are taken away, the 20 now were built, that would, yes, that would.
Secondly, if there were additional stalls built either on the surface or in the stub of the parkade, would that interfere with the amenities of your client? or materially interfere with or affect the use, enjoyment, safety, aesthetics of your client and its property.
The additional stalls underground would not have a material impact, probably because there wouldn't be accessible, there would be public.
So sorry, real quick, your mic's actually not on.
My apologies. Sorry, through the chair. The stalls at grade, for sure, would retain the stalls that we have usage of already. And that would be, yes, complying with what we believe to be the development permit requirements of 1997. So yes, they would have the ones at grade, if they were to provide extra stalls, that would have a good impact. And to remove the stalls as they have is a negative impact. But the ones underground would not probably impact our client because they're underground and they wouldn't be accessible. It would probably work better in terms of underground, because then the actual users of Lot 4 could primarily park underground, and then the at-grade stalls could be replaced for the 20 that have been taken away. And that's for Lot 4, what they've done so far. There's an additional 17 on Lot 3 that need to be retained as well. So
Thank you. Thank you, Mr. Chair.
There you go. Just the history on the property. Your client owned lots 1 to 5. And then what I assume that lots 2, whichever ones they are, 2 and 3, 3 and 4 were sold.
yes, if it's quite a, oh, sorry, go ahead with your
No,
question.
I just wonder how those lots
Came to be.
just disappeared, were sold. Or
Yeah, I have all the titles back to the original sort of 1992, somewhere in there. So they do all start off with one owner, Three Sisters Resorts, Inc. Unsurprising, because it is right next door. And it actually was part of the NRCB kind of, or resort lands to begin with. It was carved out at some point, I think, because the Marriott came in. But nonetheless, the original Lot 1, the first map I showed you that was kind of carved out, that was carved out of Three Sisters Resorts property. Now, Three Sisters Resorts property owns the title to the lot, the larger lot, Lot 1, and then it's transferred to a couple numbered companies, which appear related to Three Sisters Resorts, and then it ends up with part of the land's owned by Grand Canadian, then it ends up being owned by Paragon. Somewhere in there, the lands get split up. They were under one ownership when, probably when the subdivision occurred, creating the 5 lots. And then, that was in 2001. And then it was, various lots have been sold to various parties over time. I have the entire history. I didn't want to add it. But does that answer your question? Is there a particular point in time you want to know?
I just wonder if I owned the lots and I sold some, why would I not file an interest on that property to protect my parking on the lots that I was selling?
Because relying on the underlying development permit the same way you would rely on an underlying environmental approval, not registered, and carries on as part of a larger development is our submission on that one.
So, on the parking, is it your client's position that the 20 lots, the 20 stalls on Lot 4 that are being removed, is is your client's position there's some sort of an easement that your client has for the use of those particular lots? Or is it just the concept that by taking those 20 stalls away, that reduces the total number of stalls below 187?
Yeah, so the stalls, and I should clarify, and it may be raised by the applicant, there are 10 stalls on lot 4 and 10 stalls on lot 3, just because of the way construction is occurring right now and the fencing that have been taken away. But I should clarify that it's 10 they're on either side of that access road going up to the parkway. None of those 20 stalls are available to us right now. So I should clarify that, my apologies. So those 20 stalls that are effectively taken away right now, we suggest are covered by the old development permit. There is also the 2007 easement agreement that is registered against title that does talk about the parking stalls, that does talk about sharing. But unfortunately, that document is so fraught with interpretation issues that it's doesn't give us much to go on other than what I said previously, where according to contract law, you deal with the circumstances at the time of entering into that 2007 agreement. And the circumstances at that time were a development permit with 187 stalls. So our submission is that at that time, 187 stalls were required by the development. At that time and up to that time, the plans generally showing development of the site included 187 stalls and shadowed in developments with additional stalls that they might require. So taking that information that would have been available to the parties when they signed that contract in 2007, not some future point almost 20 years later today, because we didn't have the development we have today on the table, we would suggest that the 187 stalls is what was in the minds of the parties when they signed that agreement, and that the underlying development permit was in play, had not been modified significantly or at all with respect to the stalls. So that's, to me, the factual framework that comes into play when interpreting the 2007 easement.
So is your client's position that those 20 specific stalls have to remain? Or
If
is
they,
it,
oh, sorry. go
or
ahead.
is it that the applicant has to, if those 20 stalls are taken away, then they have to be replaced somewhere else on the applicant's property?
We don't disagree that development permit has them in a particular location and they are allocated in a particular location, but they don't have to stay in that location necessarily. And that's where amended development permits come into play and that type of thing. So as long as, quote unquote, we were made whole with respect to what we originally granted, then that would work. Honestly, I had no idea how tight the site was and how difficult the parking is to probably modify at this point, but nonetheless, it's not a site where you can add parking stalls easily. So retaining the parking stalls we have over the last 25 years of usage of the property is not a minor item. So we would be willing to consider the 20 stalls in another configuration so that we're made whole, but that's not what is proposed.
Okay. In the development permit, there's a 10% variance for the height. You're not objecting? I just want to clarify, like, that's not an issue.
Sure, through the chair, from the view study that was done, it's an extra meter, and from my experience, we always anticipated some development going in. Did we anticipate it so close and so much? No, but we did, it was known that something would go in at some time, so we don't take exception to the 1 meter difference in height, 1.2 meters or whatever it is.
And then I just want to clarify one other thing. In your submission, you were talking about another 10% variance related to the parking, I believe. Is that because there were 187 stalls and 20 are being removed, and that's greater than 10%? Is that, I just want to make sure I understood the point you were making.
Yeah, yes, the 187 minus 20, and then they're only putting in 29, which doesn't even get them to what they need. So that's, the land use bylaw requires parking stalls for each quote-unquote use. So our use required 187, and their use requires 29. And we're
I
not
see.
ending up with,
And
sorry. go ahead.
and the applicant is adding 9, which is less than 29. 10, yeah, okay.
Yeah, that's how we calculate the variance, which is over the 10%. And we're not suggesting that this board can't necessarily grant variances over 10% via 687 3D. That's the variance provision in the Municipal Government Act. What we are saying is that this application actually should have gone through CPC, which we suggest should have been done, and according to Thomas' case, this board can't do.
That's all.
Thank you, through the chair, Ms. Anderson, for your presentation today. During your presentation, you talked about the original development permit guaranteeing or allocating 187 parking stalls. But that language confuses me. Does it not require 187 parking stalls to be provided? And those stalls were provided through an agreement? And then now we're here today, and I'm wondering if your concern is whether or not you will have access to the parking stalls on another parcel of property, or whether or not your concern is that your client's property now becomes non-conforming from the original development permit.
That has been, we did think about that as well, as to what exactly it means, and I do believe that may throw us into non-conforming as well.
But would it be non-conforming based on today's land use bylaw?
Well, and that's we're suggesting that you need to actually not just disregard DP 1997 is essentially what we're saying. You don't just get a blank slate for lots 3 and 4 to develop what you want. And so the analysis that occurred with respect to this development falls woefully short of properly assessing the original development permit. When you add development permits onto a property, you don't just get to disregard or eliminate a development permit that already exists for that property.
But we are bound by today's land use bylaw as the Subdivision and Development Appeal Board, not the bylaw of 1997 that calculated 187 parking stalls. So how does this permit require a variance on this subject parcel under today's land use bylaw for parking is what I would like to understand. Thank you.
Yeah, and our submission is that in order to apply today's land use bylaw, you don't get to eliminate what was there previously and is still existing and relates to the development that was originally built. I do agree that the 29 stalls need to be evaluated with respect to the current land use bylaw, but you don't get to eliminate parts of the old development permit just because they might have been approved in an old development or an old land use bylaw. A development permit is crystallized in time at the point at which it is released, built, and therefore the 187 stalls are crystallized in time a while ago. If you're going to add a new use, you've got to add parking for that use, which is 29 on top of the 187.
But then subdivision occurred, right? So it's crystallized and then subdivision occurs. So then at subdivision, it becomes a new parcel. And the private agreement around the shared parking doesn't feel like it's relevant for this board. So I just want to understand how that private agreement, in your opinion, falls under our jurisdiction in the land use bylaw to consider this parcel today under today's land use bylaw.
Yeah, I don't disagree. There's a question as to whether that easement agreement, 2007 easement agreement applies and what exactly it means. That's a question for this board to assess. I don't disagree. Typically, you can only amend a development permit. Well, if you're going to amend parking, you have to actually go back to the development permit and amend parking. You don't get to amend it by subdivisions. Like, so the 187 and then subsequent subdivisions, you don't amend parking at subdivision. It's amended at a development permit stage. You actually need to amend that development permit, and that was never done.
But then every time we update the land use bylaw and we change the parking requirements for our community, then how does that then apply to new development moving forward if every single thing that's been approved in the past under past land use bylaws is crystallized in time? I don't understand how that works.
Sure, so if you have a development permit for, say, a mall, and you have a set number of parking stalls at the outset for the mall, each new change of use that's coming in is actually not changing the structure. It's actually just changing the occupant. But the parking stalls are divvied up at that original development permit stage. And then they're crystallized at the original development permit stage, and then you divvy them up amongst new lots. That's with a development that's built, and that's with new occupants in the actual units. Ours is a development that's built, but we're not changing occupants within the building. If we're changing occupants within the building, sure enough, we'd all have to share the 187. We're not. This is actually a completely new use, a completely new building. So unlike the mall example where the mall is actually built and you just get change of use applications for various tenants, this is not that. We don't have somebody coming into our current building. We don't have somebody who's already supposed to share in the 187. So I don't disagree with you in the sense, through the chair, sorry. I don't mean to be so impersonal. I don't disagree that it's difficult to determine what applies now and what applies back then and how the two intersect. That is not an easy question for this particular file. But there has to be some acknowledgement of the original development permit and the crystallized 187 stalls and where they sit in relation to a new development that appears to disregard them and then falls short. That's the whole crux of what's, I think, before you is how exactly that all gets sorted out. And I don't disagree that the 2007 easement is a bit of a question. I also don't disagree that the shared parking arrangement in 2007 should not qualify for the 2.7.2 shared parking arrangement because it was signed at a time when the proposed development wasn't wasn't before them. So it's not an easy question, but our position remains consistent that you've got to acknowledge 187 stalls in some fashion, and you don't just get to start removing 37 of them with the lot 3 and lot 4 without providing stalls back in some fashion. Sorry.
Anything further for clarification? Thank you for answering the clarification questions. If the applicant would like to do his presentation this time.
Again, for the record, Rick Roll, agent for the applicant and the developer property owner. We have a team presentation. With me today are Chris Sparrow of Metaphor, who are the applicant for this particular development permit application. I have also with me 2 team members from the developer, Nature's Edge, Jamie Findley and Suzanne Koshian. They only will be available for potential questions that I can't answer or Mr. Sparrow can't answer. I'm going to turn it over to Mr. Sparrow for the PowerPoint presentation. For the record, I want to just make a comment about the revised plans that you accepted. They're a part of the record already. Mr. Sparrow will speak to those revised plans. Additionally, we, as a preliminary issue at the start of the hearing, we also have a few pages of a landscape plan, what are actually part of the revised plans that were not submitted on the Tuesday package and didn't make it in your material package. But Mr. Sparrow in his presentation will speak to that. And then finally, after he has made his presentation, I will wrap up with a summation and responding to the more detailed arguments of Ms. Anderson. If the board wants to wait for questions after we finish both presentations, that's fine, but with your indulgence for the technical details, we're happy to answer your questions after Mr. Sparrow has finished. Thank you. I'm going to turn it over to Chris.
Thank you.
Thanks, Rick. Through the chair, good morning, everyone. My name is Chris Sparrow. I'm a principal and architect at Metaphor, and as noted, we are the applicants on the Nature's Edge development permit application. The presentation I'm going to give today, I want to start with an introduction to this really unique and incredibly complex site, and walk you through the logic that we applied in designing the site and bringing it together, and then address some of the concerns that were raised by the appellant. I think the appellant did a good job of describing the location and nature of the site, but again, to clarify, the parcel in question today is 99 Sisters. The address is 99 Three Sisters Drive. It is adjacent to 95 Three Sisters Drive, and as noted, the 2 parcels were consolidated. However, the land use districts that were assigned to each parcel still remain and are distinctly separated. On the bottom right-hand side of the slide, you can see the boundary of the CRD district, and can note that it is an expansive district. It is not restricted to one parcel, but is now in fact expanded over a number of parcels. However, in the land use district for the CRD, setbacks are only assigned to the perimeter of the entire district and not specific parcels themselves. It's a distinction that we want to make. In terms of the existing conditions that we encountered when we were approached with the site, I would note that it is a very complex site, as mentioned earlier. It deals with steep creeks issues, wildlife corridor adjacency, historical undermining. There's 11 meters of grade change on this site from the south end to the north end of the site, over 30 feet. There are 8 registered instruments on title, existing utility right-of-ways that service the adjacent Worldmark Hotel private development through our parcels, an unusual parcel boundary, and an unusual land district. And the diagram on the right just shows some of the encumbrances and how they impact the developable area of the site. Essentially, the entire right side of the site, or east side of the site, is undevelopable due to an access easement. We have a projection from existing parkade from the Worldmark that impacts us, and we have some undermining encroachments, which we undertook additional undermining studies to have mitigated, and we have an easement for access to a stair and patio. So the way that we approached the site, and in order to come up with a relatively simple solution to a very difficult problem, was to start with circulation. Access to the site is only provided directly off of Three Sisters Drive through the Worldmark site to number 1 on the plan shown here. It's basically the only point that we can access the site that's not a highway access, which is no longer supported as a direct access to the site, because you end up with people turning left on a highway. It's not a good scenario. So our solution was to extend an east-west street that goes all the way to the access agreement for Three Sisters Village on the right-hand side that allows them to retain their access, and then a north-south street down across the site that basically allows us to resolve the complexities of the western parcel boundary by creating opportunities for some of the discrete elements of the site that would be required, namely surface parking. It allows us to navigate and bypass the parkade, fan, projection, and easement, and also to add additional discrete elements as required, like lighting and landscaping. What this organization allows us to do, and what I would note here, is that the baseline perimeter setback for the parcel is shown here. That baseline perimeter is permitted to be altered at the discretion of the development authority per the CRD district. It is not identified as a variance requirement. And so we worked with administration to revise that setback condition to allow for the development to fit within the site. Around this sort of skeletal structure of circulation, we located our buildings. 3 buildings, visitor accommodation, one on the north end of the property facing the highway, 2 as far east as we could possibly locate them given the restrictions that we're facing over in that area. What's really unique about the way that we did this, or we think is intelligent and actually to the benefit of the adjacent development, is that we oriented the units inside these buildings so that the patios, decks, kitchen, living, and dining areas are all facing away from the Worldmark Hotel. In building A, they face to the north, and in buildings B and C, they face due east. By locating the circulation between the buildings and the existing hotel, we were able to maximize the amount of separation that we have between the Worldmark Hotel and the proposed development. We think that is a reasonable approach to mitigate issues of overlook and also to support the height variance that was requested. One of the concerns that was raised was the lack of a comprehensive plan. The CRD district does make note of a comprehensive plan. However, the term concept comprehensive plan is not defined in the land use bylaw, and that gives the development authority discretion to determine what information is needed and what constitutes a comprehensive plan. The clip in front of you is from DPA 102, which was submitted in our second submission in February of 2024. This was received and considered to be a comprehensive plan. In the amended plans that were submitted, we have updated the title block to provide clarity in this matter. Touching again briefly on the proposed setbacks, I've just kind of washed everything out to show you what's changed from that baseline 9-meter perimeter setback. We are proposing a 0-meter setback between the CRD district, which again is confined to lot 4, and the CC district, which is on lot 3. We are then proposing a 4.5-meter setback along the front of the site, and then we have curated a 7 to 9-meter setback along the east side of the site that then extends down to a point where it becomes a 15-meter setback. The 15-meter setback at the bottom of this plan was revised in the amended plans to ensure that it is in compliance with the statements in the CRD district, but we believe that that is an administrative change, given that there's discretion in assigning them, and neither the buildings or any of the site elements related to that setback area has changed. In terms of massing, materiality, and form, we know the initial concern raised was the height variance that was granted. I've provided the elevations here and highlighted the portions of the proposed development that encroach into the area above 12 meters, between 12 and 13.2 meters, which is the 10% setback zone. You can see in the kind of top center elevation, which is the elevation that faces the world mark, that the encroachments, it's not the entire mass possible for encroachment, and that they're done in a respectful way to allow for chimney visual appearances and gables in an alpine contemporary style to be applied to the building. The previous image was with respect to buildings A and B. Building C has a slightly different aesthetic and a slightly different unit type, and also is part of the variance request, but has a much smaller encroachment in terms of percentage of area that encroaches. Here is a rendering of the proposed development. This is from the east boundary of the property, the southeast boundary looking due north. You can see that the form and character of the buildings are done in a contemporary mountain aesthetic. I'd note that the patios at grade that are shown here are integrated into the landscape and are not attached to or hanging from or considered part of the buildings. The second image is from the access point at the top of the appellant's parkade access. Looking due east into the site, building A is on the left and building B is on the right. And you can see how the separation that the circulation network creates between our proposed buildings and the existing development is quite substantial and allows for landscaping, parking, appropriate circulation, including emergency response. And it's really quite nice spatially in terms of the way that it's conceived. In response to ground one, the image on the left was what was included in the application, in the development permit application, and the image on the right is the revised plan. The area defined in purple is the boundary of the CC district, and the kind of orange tan color is the boundary of the CRD district. We had proposed that some discrete landscape elements supporting the overall development encroach into the CC district. We, along with administration, do not interpret that those constitute a use per se. However, we recognize that this may be of concern, and we're proposing to relocate these elements due east to be entirely within the boundary of the CRD parcel to sort of alleviate or address any concerns that have been raised. This image here is just an enlarged version of the plan, and you can see clearly that The pathway elements that provide access are completely outside of the CC district, including pathway accesses on the left, and Building A itself is also entirely out of the CC district. We believe that relocating these elements to this portion of the plan would not duly interfere with the appellant's use and enjoyment of their property, and it is a reasonable request to address the concern. On the following couple of slides deal with the parking scenario. I think the appellant did a good job of describing the existing scenarios. So I'd put these slides together just to show kind of what the evolution across the comprehensive plan would be in terms of our understanding of the parking. I'm not going to go into that into too much detail. I did want to note, though, that as a part of the application, the appellant is suggesting that because there's more than a 10% variance on minimum parking, that this would need to go to Canmore Planning Commission. However, Section 114.1.1 of the Land Use Bylaw provides a list of variances that require, that would be permitted at Canmore Planning Commission, and minimum parking is not included on that list, only maximum parking. So I just wanted to point that out. Any parking under the required limit would be at the discretion of the Development Authority, based on my understanding of the bylaw. And on the following slide, throughout the development or the completion of the development of our comprehensive plan, we would be anticipating that we would have 103 surface stalls at the end of the day. However, development does take time and is sequential, and so I just wanted to share this for context. Oops. Getting into the applicant's or the appellant's ground number 3, they stated that there was no comprehensive plan and setbacks provided, and demonstrated earlier, and also shared the administration's approach to identifying and assigning the comprehensive plan, which is shown in front of you. They're also suggesting that the proposed development does not meet the setback requirement of the land use bylaw, so I thought I would just put that section up, because it's really weird. 411.3.5 starts with a clause that deals with building height, and then moves to another clause that deals with building height, and then deals to a clause with a subclause that deals with setbacks. So it's somewhat unusual to see setbacks defined under height. However, it does note here, which I've highlighted in yellow, that at the discretion of the Development Authority, the perimeter setback for any portion of the zoning boundary may be decreased to 0 if a portion of the perimeter is increased to a distance greater than the minimum setback to a maximum distance of 15 meters. And we take this, and we believe administration's perspective as well, is that this gives them discretion, it's not a variance, their discretion to allow the curation of setbacks to accommodate a comprehensive resort development. Below this, it's also noted that the setbacks for side yard, front yard, and rear yards shall be determined as part of a comprehensive plan and will be determined according to the requirements of the building code, which is also an unusual request to see in a land use bylaw, because the Alberta Building Code does not in any way evaluate building occupant safety or life safety via setbacks. It does so through limiting distances and combustibility and protected openings, which is the allowable of unprotected openings on an elevation of a building relative to a risk and an assigned dimension. It's possible to build buildings right on property lines, and so at the time that we're exploring and doing design work for development, we know that we have flexibility to design a building to be compliant kind of anywhere in a given location, provided we meet the requirements of the building code, which are typically evaluated at a building permit stage when further study and evaluation are done. But we can confidently say that the buildings as positioned on this site will comply with the requirements of the Alberta Building Code for safety. Coming back to the proposed setbacks, I think I've covered this sufficiently previously, but I did provide a slide here just to show how we have curated the setbacks in a highly detailed manner. so that it's clear for your evaluation to understand that they're compliant with the previous slide. In response to the applicant's initial appeal, I know that they have stated that they have no further concerns with the visual impact study. I did, or the overheight variance request, but I did prepare a couple of slides. I did want to note that the buildings range between 12 and 35 meters away in distance from the existing Worldmark Hotel. If I was to build a 35-story glass tower in Calgary, 12 meters would be the minimum distance that tower would be permitted to be from a adjacent tower, and those towers are usually floor-to-ceiling glass. So for an alpine-style visitor accommodation property with about 80% opacity, the distances I think are more than sufficient and reasonable. And we have the same slide for building B, but I won't go into it. We had also taken a couple of photos to note that at least at the parkade side of the development, where the parkade fan extends into Lot 4, the size of openings in the elevation of the Worldmark Hotel are not super, they're not large, probably likely restricted to bedrooms, and we didn't feel that the proposed development building locations were necessarily unduly interfering with the use and enjoyment of the property. And we saw these images before too, showing the portion of the elevations that are encroaching into the setback. So I'll just rip past those. There was a comment in the appellant's initial response that had to do with headlights and potential trespass. There was also some commentary about the fence and it not being screened. We selected the fence to be able to be tied into the fence that the Worldmark Hotel has installed on our property, the black chain link fence, so we have no issue just carrying on that fence and that aesthetic. It should be noted that the vast majority of our parcel is substantially lower than the adjacent hotel, and that the parking stalls that are being proposed along the internal site circulation range between about 2 feet to a meter below the slab datums of the hotel, and as high as 2.7 meters below. With landscaping and the separation, we feel that there, as well as the height of the sills of the windows of the adjacent building, we don't feel that this is going to create any issues in trespass. Will be very similar in many respects, or even better than the situation that the surface parking at the frontage of the hotel has on the Worldmark Hotel. And this was a section just used to define that. I'm just going to pop out so I can share with you. I included the landscaping plans that were shared this morning in here, so I'll just share them with you. There's 4 pages. And so the cloud at the top of the plan addresses the relocation of or it just identifies the area of the plan that's changed. All of the clouds that are kind of working down the right or the east side of the plan are more or less annotative and just have been added to clarify the annotations in the original plan. This is related to the way that setbacks were described, or the nature of the way that setbacks have been described. So just making sure that that clarity is really clear in the plan for your evaluation. And then the second page takes all of the related planting to support the landscaping and confirms that it can be relocated into this portion of the plan in compliance with the land use bylaw. And because that portion of the adjacent site was considered in the landscape calculations, we've also had the calculations updated as well. And that is the cloud on the right-hand side of this plan. And that's the end of my presentation. If there's any questions, I'd be happy to answer them.
Just one point of clarity, if you noticed, you're listed here that the total amount of parking stalls will be 103 by the time this is done?
The surface parking stalls, we did a survey, a visual survey based on what we could see on mapping. And we believe that 103 parking stalls, surface parking stalls, would be provided by kind of at the completion of the comprehensive development. With, you know, a large portion of those being contributed by the Worldmark Hotel.
Thank you. Any?
Thank you for your presentation. I was wondering if you could pull up a site plan and just go through all of the stalls for us so I can see the indoor, I guess, parking garage and outdoor surface stalls. I saw some reference to 17, but I heard earlier reference to 29, so I'd just like to be clear on what your current proposed development will provide for parking.
Sure. So 12 parking stalls are enclosed and provided in garages in the within the buildings themselves, and so you can see the garages in the elevations here. They're not referenced directly on the plan. And then there are 17 surface parking stalls with 16 of them are located on the left, and there's one additional stall located on the north side of building B to the right, adjacent to the snow storage area.
Thank you. And is there room on the plan for additional stalls right now?
Yes, there is room on the plan for additional stalls. A variance was applied for to add additional stalls to the parcel, and it was rejected by administration as it was deemed that that couldn't be supported due to the transportation master plan, the NTP.
Could you describe for us where those stalls, some of those requested stalls were, just so that we can understand?
Yep. So those stalls were proposed over here on the right side of the plan, which is now snow storage area. But initially we had an additional 3 parking stalls over here.
How many?
3.
3. Thank you, Mr. Chair. Thank you.
Just one question on your vehicle headlight assessment. If you could explain that a little further, what the purpose of that is and how you arrived at?
Yeah.
Was that through discussions with planning, or is this something that is kind of a standard planning?
We prepared this slide just in response to the appellant's comments related to light trespass. It was the last comment in their application from last week, and we did some research, and we understand kind of what the median height of a headlight is on most vehicles, and the delta, the difference between the parking level grades and also the intensity of landscaping and grade, as well as the distance that the parcels are away. And we felt that the headlights should not be a major nuisance for the adjacent development. However, noting that we do have chain link fence on the site, we'd be happy to screen it if that would satisfy the board. So with the use of vinyl siding.
Would it be fair to say that was with mitigation of impact on the neighboring property in mind that you do an assessment like that, or is this just a standard architectural?
Yeah, we're always paying attention to grading, especially out here in the Bow Valley. With 30 meters of travel across the site, we're doing the best that we can, and working within the engineering and design guidelines for slopes of roadways, and we're trying to pay attention to where some of these things lie, where they lie relative to adjacent buildings, and ensuring that we're doing something to make sure that we're mitigating negative impacts where possible.
Okay. Thank you for clarifying that. Any other questions? Okay. Thank you. I believe Mr. Grohl's.
Thank you again, Mr. Chair. Rick Roll for the record. First of all, this is an interesting appeal. the one, and then we appreciate that the board accepts the revised plans as part of our submission, and would like you to consider them in determining the appeal. As the board is aware, you are a quasi-judicial board where to hold hearings, what are hearings de novo. So it's been in your purview, in our opinion, to accept these revised plans as part of the adjudication of this appeal. And first of all, I think this is an interesting appeal, but first and foremost, I think this is a permitted use. And it's very clear this application was for a permitted use in accordance with the land use bylaw. And under the scheme of the land use bylaw and the Municipal Government Act, a property owner that applies for a permitted use application is entitled to a permit. As a matter of fact, the authority must issue the permit if it complies in all aspects with the land use bylaw. In this case, my client only sought one variance, a height variance. And I'm glad that Ms. Anderson, on behalf of her clients, basically says that they have no position with it. You heard from the Development Authority, it meets the test for variance as set out in the land use bylaw. It also meets the test of section 687 3D of the Municipal Government Act. Your test is broader than the test which is more stringent for the Development Authority, but there's no evidence to indicate that the proposed development materially interferes with the use, value, and enjoyment of the adjacent property of Ms. Anderson's client. So the only issue left in her argument is basically under the permitted use application, the parking variance. We respectfully disagree. The Development Authority, in our view, appropriately assessed this application under the standards of the current land use bylaw in effect. And the current land use bylaw in effect for this particular development requires 29 stalls, as you heard. They are provided. And with that in mind, we believe that the whole issue that Ms. Anderson, on behalf of her clients, respectfully, I disagree with her, that somehow you would be able as a board under your jurisdiction to review this as part of the appeal. We believe that is not the case because it's outside of the scope of the permitted use, because the parking standards is met under the current land use bylaw. And the whole issue that is arising that they're losing 20 stalls, what were approved in 97 under an old development permit, was actually in effect for a larger property, is irrelevant for the current application. Because, first of all, there was a development agreement in 98. That development agreement was discharged from the title. So now typically development agreements, and Ms. Anderson tried to explain that to you, yes, they get discharged under the Municipal Government Act, and she's correct in that. It's very common they get discharged when it's not necessary to encumber a property any longer. But typically what you see is that if parking is provided under a development permit, what is also referenced in the development agreement and what pertains to other lots, that many times there is a condition in the development agreement that says that it only can be discharged from title with the consent of the municipality. Now, in this case, I don't know exactly the details, why it was discharged, but I'm assuming either there was no consent required, but they were discharged. But that brings us back to now 2001. In 2001, these lots were subdivided. So there was a subdivision done, lots 3 and 4 were subdivided from the main parcel on which the buildings of Ms. Anderson's clients were built in accordance with that 97 permit. And yes, that permit probably at the time required 187 stalls under the land use bylaw in effect at the time. I'm assuming it was a discretionary use, and as you are aware, sometimes under discretionary use you can require more parking, but we don't know what the requirements in 97 were under the land use bylaw. But we submit that's irrelevant because applicants, property owners, can make new applications for development permits. For example, this building had probably in the past a development on this land, what was built under an old development permit. But somehow the town acquired this property, I'm assuming, and then made an application to build this building in the town hall. That happens all the time. Lands are being subdivided and new applications are made. I can give you the example of a shopping mall that, for example, has parking, empty parking lots. If they subdivide the land and they sell it to another developer and then subsequently applies for a residential use in compliance with the land use bylaw in effect, they can get a new permit. Her clients, or the predecessor of her clients, created an issue as a result of their own actions by subdividing the land and not putting a registration on the land that would encumber or limit or protected their parking. They have a problem. And the whole issue, whether or not they're becoming a non-conforming use or a non-conforming development, is not for you to be reviewed, because this is not a discretionary use. If this would have been a discretionary use application, I could see that adjacent properties and the impact on adjacent development agreements and previous DPs could be evaluated by the Development Authority. But the Development Authority's hands are tied. The Municipal Act is very clear. If you meet the standards of the land use bylaw, the Development Authority must issue a development permit. And that has been confirmed in many case law. Among one is the so-called famous case Eckert versus the Kunza and Flagstaff. So now, my submission to you is that, in essence, when you have a development permit for a permitted use and somebody appeals that, as you are aware, the Act says in section 685 sub 3 that only an appeal lies with respect to a development permit for a permitted use if there is a variance or a misinterpretation of the land use bylaw. We believe there is no misinterpretation of the bylaw, because the Development Authority have accurately determined that 29 stalls are a requirement under the land use bylaw. They are provided, so that ends the issue about parking. Because parking is the main issue, as we heard today, because Ms. Anderson's clients rely on the shared parking agreement. What still, yes, that is a civil agreement between the two adjoining property owners. However, that is not for your purview to take into account when you adjudicate this appeal. Because the fact that they too losing to 20 stalls, they could make an application and perhaps remedy this through a development permit application for their own development. Perhaps the Development Authority will grant that variances, but that's not for you, board, to even take into account. Because my submission to you is, when you have a permitted use application, you have the appeal should be limited to the variance that is before you. You cannot review and open basically the permitted use like you can do and review for a discretionary use. I'd just like to go over a few issues. Somehow Ms. Anderson is also trying to allege that somehow my client and the Development Authority intentionally try to sort of mislead also this board by sort of ignoring the revisions or the encroachment of building A in lot 3 under the CC districts. That was complete oversight by drafting of metaphor. And we appreciate that she found this, and we acknowledged it. We remedied it through a revised plans. As you can see, the encroachment has been totally eliminated. Also, she makes a lot of issue about the fact that sort of the land that is part of my client's property is zoned CC district. My client has applied for a land use redesignation, and that has been held up, my understanding, by the administration because of the election. If it wouldn't have been for that, it probably would have already been on the agenda of council. My understanding is goes to council for first reading in December, but there has still to be a public hearing. Yes, there's going to be future development on that particular piece of land. You saw Mr. Sparrow showing you the intention, but that is not before you. It would be an error in law for your board to take any inference from that. It was never intentionally that somehow my client wanted to mislead. There was no intention to make that part of this application. So the revised plans address that. We would respectfully request that you take that into account when you render your decision. The issues about the civil agreements, there are 8 instruments on title. Anything, what Ms. Anderson has referenced to any of the instruments on title, the shared access and parking arrangement, for example, the easements, it is my respectful submission to you that's irrelevant for this application, because there's no variance what pertain to those aspects of this development. I'm just going over my rebuttal arguments that Ms. Anderson had made. Yes, I just want to put also this whole issue of nature about an old development permit in perpetuity could sterilize any land in the future, for example, as Ms. Anderson has basically alleged. And you asked some astute questions to her. Yes, you can speak about crystallization or not. A development permit, it cannot in perpetuity sterilize future development on land. This is now a different parcel of land that is the subject of the development permit application in accordance with the rules in effect on the land use bylaw currently. And I respectfully request that you consider that. For the rest, I ask that you consider all our written submissions. I'm not going to summarize them. I don't think it's necessary because, in my view, we shouldn't muddle the waters more than Ms. Anderson already has done. I can understand why she's trying to raise this issue before you, but we believe that any disputes about the shared parking agreements, for example, any of the instruments on title, is a civil matter, and they may have a remedy, but not in this forum. The issue, I also want to raise the issue about the setbacks. Yes, we believe that under the land use bylaw, when you have an irregular lot, and it's interesting that Mr. Sparrow shows the example of a section, the applicable section, that the development authority has been given discretion to determine the setbacks when you have irregular shaped lots, and this is exactly one of them. So there is no setback relaxation. I think I have covered everything as much as possible. Bear with me, Mr. Chair. Oh yeah, I want to speak to the issue about comprehensive. Ms. Anderson seems to be alleging that somehow this application is not in accordance with the land use bylaw because it speaks about comprehensive applications. But when I looked at the land use bylaw, the term comprehensive is not defined. It's nowhere it's defined in the land use bylaw. I'm assuming under the broad and purposive interpretation of legislation, what you have to apply to land use bylaw, it's sort of, you use the more or less what is the intent of a comprehensive plan. in my experience, is it shows as much information that is necessary for the development authority to issue a development permit. And under the dictionaries, comprehensive only means basically it's synonym with complete or inclusive. That's all what it is. And the Development Authority determined under the Municipal Government Act that this development permit, in terms of the information required to be assessed and analyzed, that the development permit was deemed to be complete in terms of the information required. So with that in mind, it's and the confusion maybe arises because this application, it shows lots 3 and 4, which are now lot 6, but essentially the CC district lot 3 is not before you, because that's my client didn't ask for it. It is shown in the drawings, but for completeness, they show what the future intention of my client is. And my client's intention is to develop that in accordance with the land use bylaw, but they need a land use redesignation for that. And with that in mind, I'm just going to ask my clients if I missed anything. So, okay, those were our presentation, and we're open for any questions. Thank you.
Thank you. Do any of the board members have clarification questions?
Thank you, Mr. Chair. Mr. Grohl, I was hoping that you could clarify for me where the applicant finds authority to relax the 9-meter setback, perimeter setback, along the former Lot 3, Lot 4 boundary in the northeast,
Yes.
Which remains the CC-CRD boundary.
Oh, can you please repeat the question? And can we put up the slide, Chris? Yes, I think it's easier to talk when we have the slide up.
Thank you. The question, Mr. Grohl, is can you clarify for the board where the applicant finds the authority to relax the 9-meter perimeter setback along the former Lot 3, Lot 4 boundary in the northeast corner?
Okay, first
Northwest corner.
Okay.
Apologies.
Okay, we believe, and I agree with Mr. Sparrow, that that is not a relaxation because it's not a variance. We believe that that is basically to the discretion of the development authority. Chris, do you want to answer it?
Sure. So the section, land use section in front of you for 1135B forms part of the CRD district, and the highlighted area does note that the development authority has discretion. Any perimeter, the perimeter setback for any portion of the zoning boundary may be decreased to 0 if a portion of the perimeter is increased to a greater distance than the minimum to a maximum of 15 meters. And so there's a bit of a push-pull, but there's some discretion permitted to the development authority to allow that to happen, and it's because it's in the district and not it's because the discretion is assigned in the district. We do not believe it's a variance.
One more question, Mr. Chair. And a follow-up question. Is there a 15-meter setback elsewhere on the proposed development?
So on the bottom right, you'll see the boundary of the CRD district. Most of the district is 9 meters. If I go back to where I was. There is an area at the bottom right by the cursor that's in magenta. That is a 15-meter setback.
And what is the perimeter setback and the balance of the east boundary?
It varies as the setback is vertical relative to the unique shape of the parcel. For a portion between 7 and 15 meters, there's a portion that's 7 meters, there's a portion that's 9 meters, a small portion at 4.5, and then a portion that goes from 4.5 down to 0 and a 0 meter between the two districts, which are now part of the shared consolidated site.
Thank you. Any further questions?
Any further clarification questions from the board?
Mr. Chair, may I make one clarification, my client? We just want to state that my client believes that they will meet the shared parking agreement, that is possible. But as I stated, my view is that in the adjudication of this appeal, it is not to be considered by the board, any inferences from those shared parking agreements, because that's a civil agreement, and under a permitted use scheme, it is outside of the jurisdiction of the board to consider any civil agreements. Thank you.
At the beginning, when we addressed the procedural matter, we made the condition that we would, made the concession that we would offer a second recess if you needed some time to review the new material, or Ms. Anderson. Will you be needing that time? Okay. Would you like a recess to review it? Okay, we'll stand in recess for an hour for those reasons. Thanks. believe everybody's here, so we'll call the meeting back to order. And I'm told we have a rebuttal from the appellant on the new materials.
Okay, good afternoon. My name is Bonnie Anderson, and we're continuing this afternoon. Again, I act for the appellant Worldmark. We did have a couple questions and are quite confused, I guess, in the comprehensive plan, which is the new submission that we just need clarified, and we don't quite understand the parking. And we understand in the lot 4 that the stalls, so there's 29 stalls provided, 12 inside, 17 outside, and the numbers just aren't adding up for us. So the outside stalls, which are 17, inside stalls 12, we have been advised that all of the outside stalls will be committed to residences. And in plans associated with the development, they indicate that the land will be condominiumized, which means those stalls will be allocated to residences. And when you're looking at a comprehensive plan, that to us suggests that there will be no stalls for sharing on lot 4. And the easement agreement 2007 on title says that it was put on title at the request of the town of Canmore. So while possibly the town of Canmore wants to wash their hands of having to address this, it's not making a lot of sense, because it appears that none of the lots, or none of the stalls on lot 4 will at all be available. And they've taken away 20, the 17 that might be available because they're outside stalls. It seems like none of those will be available. And then even if we apply the easement agreement from 2007, which says 50% of surface parking stalls must be made available, which agreement was required at the request of the town, we should at least be having access to at least half of them. So they're taking away 20. So it's either the underlying development permit, which feeds into the 2007 easement agreement as a baseline. They're not complying with that either. And I think the intention is to have 0 stalls available on lot 4. So everything that might be shared would then go to lot 3, which is on a shadow plan right now. So I'm just going to point that out, that it seems like the numbers jive, but they don't seem to when we sit down and go through them in terms of the stalls created. So that's just something from their plans. The second thing is that, and I mentioned it before, is if you're going to accept these plans, they can't be, in my view, a condition. They actually have to be accepted as part of this hearing and can't be amended later, because that zoning line is a clear no for this board. So it can't be something that's after the hearing's closed, that they go and amend it further. It has to be as part of this process. I know at least our client has additional comments on one of the slides, which I think will be helpful to throw up. And then I think Gavin McCaffrey, who's the numbers person, is kind of confused on that as well. But that's also a new item that was just shown to us. So that would be an additional comment we have.
So, my name's Gavin McCaffrey. I'm the general manager at the World Mark Resort. So, obviously, parking has been a well discussed, or we're trying to navigate a rather complicated agreement in terms of how we're navigating it. But I'll just wait for the imagery to come up here. It's just some review of some of the floor plans or development. So based on where I was going, it was brought up that the current existing parking map shows 100 parking stalls on there, and on the documentation it said proposed parking map of 97 stalls. But through the presentation, they amended that to 103 stalls, and I was just trying to understand where that was coming from. Sorry. I was getting there? Okay. I would have to count. So there's that one there? Yeah, so those two. So this one indicates the 100 stalls pre-existing and then proposed parking map of 97. Through the presentation, they noted 103. So if you go to the next image, you'll see kind of at the top where you have the 12 that are annotated, but I'm anticipating if you add all those up, that's where you get the 103, which is contrary to the prior map that showed 17 spots on lot 3. So we have an additional 6 lots that I would anticipate are now on lot 4 and not on lot 3. So just as we go through these plans, I'm just trying to figure out how I'm going to be managing my business moving forward, how we're going to develop and work on this relationship, and how we understand what is actually going to be in front of us, and just the accuracy of the information. So we're good to be good neighbors. We just need to know what it is moving forward and how we adapt our business for that. But it's just something that we've been navigating quite a bit to understand how this relationship is going to exist and what actually is going to be laid before us as it relates to parking. The reality is any shared parking in that area is going to be challenging for all businesses and residents through the development, just based on the sheer volume that we see in our business and what I anticipate will be generated through this area. But again, it's just trying to understand. I'm challenged in understanding what actually is being put forward and proposed through that. So, thank you.
Any board members have questions of clarity from the rebuttal? Okay, thank you. Okay. This time I would invite anyone in the audience who wishes to speak in support of the appeal to please approach. If there's anyone in the audience who wishes to speak against the appeal, please approach the podium. If there's anyone who wishes to speak in a neutral position, please approach the podium. Is there any additional written submissions received? Nope.
Perfect, thank you. Yes, we received one written submission that was back when we first met. So that was in support of the original adjournment request. That way everyone had the information that they needed. And then they voice kind of in a neutral capacity their overall concerns.
Thank you. I don't believe we need another recess. We just came back. So, any of the board members have any questions for clarification for administration?
Thank you, Mr. Chair. Couple of clarification questions for the Development Office. Direct my guests to Harry, Jennifer, and Mike. The first one is the application relates to Lot 6, Block 1, and we've heard a lot today and reviewed a lot in the materials about Lot 3 and Lot 4. I was just wondering if you could clarify for us what Lot 6, Block 1 is. Is that Lot 4 or is that something different?
Through the chair, that's referring to the consolidated lot. However, we were only considering the proposed development within the scope, which was through the original Lot 4.
Thank you. And my other question is relating to setbacks. Wondering if you can clarify for us whether or not the setbacks as proposed in the revised development plan that we received and reviewed this morning are in compliance with your requirements as you interpret them, and if there are any concerns that we need to be aware of. It appears as though there's less than 9 meters in several places on Lot 4, which I understand is Lot 6, Block 1, and there's only one place where it's in excess of 15 meters. So I was just wondering if you could speak to that and give us your opinion.
Through the chair, thank you for your question. So there's two pieces to this. There's the perimeter setback for the district and then the setbacks from the buildings. So the district itself does extend in certain locations beyond the property lines to the south and west. So the setbacks, the perimeter setbacks and the development like yard setbacks are determined to be in compliance in the opinion of the Development Authority with the provision outlined in the district. And as was previously mentioned, a variance is not needed if the provision gives the Development Authority discretion to adjust a specific provision within that provision, and therefore the development complies with this adjustment where there's an increase in one area and a reduction in another in compliance with that perimeter setback.
Thank you. Thank you.
I have a question for Ms. Bradshaw as well. In regard to the parking stalls, just wondering if you could speak to the town's position or any discussions or direction that might have been given to the applicant in regard to the stalls?
Through the chair, thank you. I can speak to the parking. It is our opinion that the parking complies with the land use bylaw requirements as they exist now. There was a request for an increase in stalls, and in order to adjust the maximum number or get a variance on the maximum number of parking stalls, a parking study was required as a result of that, and it was reviewed by the transportation engineer, and comments were provided back and forth on that. So the variance was not sought after all, because to increase the parking, it would require that variance to the maximum number of parking stalls. So when we reviewed the application in accordance with the parking requirements as they exist in the land use bylaw, that's the number of stalls we determined. Additionally, there is a requirement for some of the stalls, a certain percentage to be located covered. So that's part of the reason for the covered stalls in the garages.
Okay, thank you for that.
Thank you.
Any further questions for administration? Does any member of the boards have, any board members have questions for clarification of the appellant? Any board members have questions for clarification of the applicant? Do any of the board members have questions for any other person? Did any person who has presented have any questions for clarification of any other presenter? If yes, please direct your questions through the chair. Does the development officer have any closing comments?
Nothing further to add, thank you.
Thank you. Does the appellant have any closing comments? Or, sorry, a bit of an error in the script here. Does the applicant have any closing comments? No. Does the appellant have any closing comments?
Thank you. Just a couple points. It has been said over and over again that this application was a permitted use from the get-go. I can tell you that they wouldn't need to take out that little triangular part if that was the case. It was actually a permitted use and a non-use. So to characterize this as a permitted use application from the get-go, no relaxations or just one relaxation was actually not the case. It actually was a permitted use and a no use. So I just want to clarify that. And the triangle needed to be addressed because that did not even have the listed use. So, and that's what we consider to be a misinterpretation of the bylaw when that type of thing is approved, because the development authority cannot approve even part of a parcel with a use that's not listed. So it was indeed another variance or a misinterpretation. So it sounds like all the time that this is a permitted use application, one variance. It actually is not. So I think the proper characterization is important because we're not coming here complaining about something other than a very, very specific rule in municipal law, specifically for that little triangular area. The other item is, as discussed, was just the shared parking and the parking. It's quite complex, and at the end of the day, we hope that we'll get some clarity on this item going forward, because we've also got Lot 3 to contend with. So whatever comes out of this is very important. The other item regarding the zoning is that it kind of continues to be, you know, we didn't know, it was just last stuff, this is why we're doing this now. It's known for a long time. So I don't want to complain about this stuff, but I wish it wasn't something that I had to complain about, because it should have been dealt with a long time ago. And the last item I did want to comment on was thanks for your patience. It's a complicated topic. It's an old site. It's got old stuff. It's got new stuff. It's got an old land use bylaw, new land use bylaw. Different parties owning different parts of sites now. So I appreciate your time, and I appreciate the Development Authority and everyone who's here today to kind of muddle our way through this, and hopefully you'll get a decision out of it that we can at least use going forward. And appreciate engagement with the applicant as well in terms of just everybody being here, because this is not an easy appeal. If it were an easy appeal, we probably wouldn't be here, or it'd be solved already. So your direction and guidance going forward is appreciated, and your time today. Thank you.
Does everyone who presented today feel they have had a fair hearing? The hearing is now concluded. As a reminder, the board will meet in a closed session to review the evidence presented, provide a written decision within 15 days of the hearing. No decision is binding on the board until it issues a written decision. The clerk will provide notice of decision to both parties and post notice to the town website. The meeting adjourned. Motion to adjourn? Motion.